Takes us to page 6. Page 6. Special order S423. Senator from Beaufort, what purpose do you rise, sir?
To be heard on the bill.
For explanation of bill. Senator from Beaufort is recognized. Senator from Beaufort.
Thank you, Mr. President. I rise for the purpose of explaining this particular bill, which is commonly referred to as the Compassionate Care Act, which is, those of you who were here a couple years ago will remember this is the bill that would allow doctors under certain limited circumstances to authorize patient use of marijuana or cannabis. The two terms will be used by me interchangeably for medicinal purposes, provided that the patient was diagnosed with a certain underlying condition. And by way of review, this particular bill underwent not this particular bill, but the subject matter underwent 3 full weeks of debate in the Senate 2 years ago, and ultimately it passed by a vote of 28-16. And then it went over to the House. It was assigned to the 3M committee in the House. It moved through that committee process and got on the House calendar. It then came up for debate in the House with about 2 or 3 days left in the session. And as the members will recall, there was a point of order raised in regard to that bill, stating that there was a revenue-raising component in the bill, and that therefore it should be properly characterized as a revenue-raising bill under the meaning of that phrase in the state constitution, which says that a revenue-raising bill must originate in the House. Now, that is a question that I had contemplated when I filed the bill in the Senate, and I worked very carefully with Senate staff, and we reviewed the case law in regard to what constituted a revenue-raising bill. And the Supreme Court has interpreted that phrase in the Constitution on a number of occasions, and the overriding thrust is this, that if the primary purpose of a bill is to raise revenues for the general fund, then it's a revenue-raising bill. However, if there are revenue-raising components to the bill that are ancillary to its primary purpose, then it's not a revenue-raising bill. And given that particular Supreme Court analysis, we felt confident when I drafted the bill with Senate staff that it was not a revenue-raising bill. No point of order was raised in the Senate in that regard, but it was raised in the House. And the Tommy Pope, who was the presiding speaker at the time, ruled that it was, in fact, a revenue-raising bill. Therefore, it was not properly before the House because it had not been originated in the House, and it was struck down. So that ended the bill for 2 years ago, and then last year, as you'll recall, we tried to set the bill for special order debate, and it got wrapped up and went sideways, I think in the wake of, in my opinion, abortion politics. There were several individuals that were upset that I had filibustered and defeated a bill that would have banned abortions from the moment of conception without the exceptions that I thought were appropriate. But be that as it may, the bill did not get set for special order last year. This year, it has been set for special order. So I'm going to go through relatively quickly what's in the bill. I don't think there's a lot of need to plow the ground that we did 2 years ago over a 3-week period of time, although there are some new members of the Senate. I've talked to some of those new members about this bill, and I think they're fairly familiar with it, but I want to hit the top lines of it. Now, when talking about whether or not our state should adopt as a matter of public policy empowering doctors, letting doctors in consultation with their patient decide on what is the best course of medical treatment, and deciding on whether or not we should adopt that as a state policy, I think the responsible thing to do is to first ask ourselves, do we have the authority to do this? Can the state do this? because the federal government has acted in this space back in 1970 through what's called the Controlled Substances Act. It enacted a law that characterized marijuana or cannabis as a Schedule I drug, okay, which by definition means it has no medical purpose and it is subject to abuse. And so therefore, like heroin is, for instance, a Schedule I drug. So marijuana was lumped in with heroin back in 1970. So the first question arises, has the federal government preempted in this area? Can the state act in this area when the federal government has already acted? And the answer to that question, I would submit to you, is no, there has not been federal preemption, and this is why. First of all, the language of the Controlled Substances Act itself states as follows, and this is reading directly from the Federal Code of the Controlled Substances Act, 21 U.S. Code, Section 903. No provision of this chapter shall be construed as indicating an intent on the part of Congress to occupy the field in which the provision operates, including criminal penalties, to the exclusion of any state law on the same subject matter. Now, that is the antithesis of preemption. That is expressly stating that this federal legislation does not preempt. That is the express language of the Controlled Substances Act, that it is not the intent of Congress to occupy this space to the exclusion of any state law. But that doesn't end the inquiry, because that just speaks to that there's no express preemption. The question then arises, is there an implied preemption? Does the state, or is a state acting in this space somehow by implication affect or obstruct, obstacle is the word that's used by the courts, is there an obstacle to the federal government implementing the Controlled Substances Act? And this matter has been considered by federal courts on several occasions, and I'm going to read to you that it was ruled to be not an obstacle because, quote, the immunity state law provided in regard to a medical marijuana law that was passed in a state did not alter, interfere with, or undermine federal enforcement of the Controlled Substances Act. So there's nothing about a state acting in this space as a matter of state law that is an obstacle to the federal government implementing the provisions of the Controlled Substances Act. So there is no express preemption. I read you the language of the Controlled Substances Act in that regard. And there is no implied preemption because there is nothing about state law that prevents the federal government, if it chose, to enforce the Controlled Substances Act. So let's put aside the argument that the Supremacy Clause somehow prohibits the state from acting in this space. It does not. And primarily that's one of the reasons why you've got 38 states, soon to be 39 states, along with the District of Columbia, occupying this space in terms of medical cannabis without interruption by the federal government, because they realize there has been no preemption. Now, but in addition to that, every year Congress passes a rider to its budget. The same rider every year. It's included automatically in every appropriations bill that is passed by the House, by the Senate. It is never subject to being modified. It is never stripped out. It is a barnacle that follows these Appropriations Act for the last dozen years. And it states as follows in regard to the Department of Justice, which of course is the branch of the federal government that would enforce the Controlled Substances Act vis-a-vis the states. And the proviso or the rider says this: none of the funds made available under this act to the Department of Justice may be used with respect to any of the states, and then it lists all the states, 38 states that have passed medical marijuana laws, to prevent them from implementing their own laws that authorize the use, distribution, possession, or cultivation of medical marijuana. So we not only don't have any federal preemption, either expressed or implied, in the Controlled Substances Act, you have in the budget that is adopted by Congress every year a rider that expressly states that no monies, no federal funds that are appropriated can be used for the purposes of preventing states from implementing their own medical cannabis laws. So you have that at the federal government level. In addition to that, over the last several years, the Internal Revenue Service has published on its website and has distributed to accountants throughout the country a regulation and rule that, quote, provides resources to help cannabis business owners successfully navigate unique tax responsibilities. So the Internal Revenue Service has promulgated regulations in contemplation of the fact that states have medical cannabis laws, that there are medical cannabis establishments, and they tell you exactly how you're to file your taxes. Yet another indication of the federal government acknowledging and recognizing the legitimacy of state action in this space. In addition to that, you have promulgated by the U.S. Department of the Treasury regulations and guidelines and protocols to be followed by lending institutions, banking institutions, as to the receipt of funds arising from medical cannabis establishment commercial activities. So in regard to that first question I just raised to you, can the state act? Do we have the power to act? Conclusively, I think the answer is yes. Not only empirically by the fact that you have 38 states and the District of Columbia that has acted in this space without being challenged by the federal government, but because of the language of the Controlled Substances Act itself, saying there's no express preemption, because of the federal court ruling saying there's no implied or obstacle preemption, because of the Department of Justice rider in the budget that says no federally appropriated funds can be used to interfere with a state implementing its medical cannabis laws, and because we also have federal agencies like the IRS and the Treasury Department, which regularly interact with medical cannabis establishments, promulgating regulations and issuing guidelines on how they can discharge their federal duties. It is difficult to imagine anyone arguing that the federal government hasn't ceded this space or acknowledged the state's right to exist in this space. So that's the first part of my argument. Now, of course, answering the question of whether or not the state can act doesn't get to the question of should it act, okay? Just because we have the authority to do something doesn't mean that we have to do something. And I want to start with how I came to the position that the state should act in this space. And it starts with anecdotal incidences, but then moves into peer-reviewed empirical medical journals and documentation in regard to the medicinal aspects of cannabis. But I want to start with the anecdotal. My friend Margaret Richardson, many of you know Margaret Richardson. She is the wife of Scott Richardson, who used to be the state senator from Beaufort County, in fact, had the state senate seat that I now hold. She has testified before a medical affairs committee. Many of you who were here 2 years ago remember I put up on the screen her testimony talking about her condition, trigeminal, I always mess it up, trigeminal neuralgia. Trigeminal neuralgia is what she has. And let me tell you what that is. It is a condition that causes intense pain similar to an electric shock on one side of the face. It affects the trigeminal nerve, which carries signals from the face to the brain. Even light touches from brushing your teeth or putting on makeup may trigger a jolt of pain. Now, Margaret has this condition. She has taken pharmaceutical medications to address this condition without any relief. When it attacks her, she testified to Medical Affairs Committee, she howls like an animal in pain and curls up on the floor screaming in pain, like she has a hot iron put on the side of her face. None of the pharmaceutical medicines that are prescribed to her alleviate that pain, Senator from Charleston. They don't. But you know what does? One puff on a marijuana joint or some cannabis, one puff, the cannabinoids in that marijuana impact with her cannabinoidal structure in her, and they alleviate that pain. So the question I would ask anybody in this chamber, if you had a wife that was screaming in pain, or a husband that was screaming in pain, none of the prescription medicines provide relief, but there is something on that nightstand that if she takes one puff of it, makes that pain go away, would you stand in your spouse's way and say, no, I can't let you do that. You need to stay curled up howling in pain because that's illegal under South Carolina law. I don't think anybody in this chamber would do that. I hope they wouldn't. Hope they wouldn't. Given that's the reality, it is incumbent upon us to provide a means whereby people like Margaret can access that medicine safely, under a doctor's care, with a pharmacist dispensing it, with knowledge that what she is consuming is safe and isn't adulterated. It is our job to do that. I don't think anybody in this chamber would do that. Senator from Greenville, Senator Corbin, if your wife was howling in pain and you had something on your nightstand that could give her immediate relief, would you tell her no? Would you tell her no because it's against South Carolina law? If your daughter or your son, no, you wouldn't. You'd break the law. But why make them break the law? Why make Margaret Richardson go out there and buy marijuana on the street not knowing what she's getting, not knowing if it's safe? Why make her do that? 38 states don't require that. 38 states recognize that the humane thing to do in that circumstance is to figure it out. Figure out a way that we can safely get this medicine to people who clearly need it. So that's what this bill is about. That's what got me into this. Now, I recognize we can't make laws based on anecdotal evidence like that alone. I get that. As compelling as those anecdotal stories are, in my opinion, you can't make policy based on stories. You can't make policies based on just firsthand accounts like that. So I did a little bit of digging. And it turns out it's not just Margaret Richardson telling me it provides relief. It is the overwhelming weight of medical authority that says that there is something about the cannabinoids in cannabis that interacts with a body. Your body has an endocannabinoidal system in it. And a lot of the neurological disorders and a lot of spasticity problems and chronic pain result from the imbalance of your endocannabinoidal system. There's something about the way the cannabinoids interact with your body that addresses the underlying causes of that pain. Doesn't address the symptoms of that pain like opioids does, addresses the underlying cause of that pain. And it's backed up by peer-reviewed study after peer-reviewed study after peer-reviewed study. We used to say, 10 years ago when I first started this, and this is my 10th year of trying to get this passed, there used to be buttons out in the hallway, in the lobby, that law enforcement would come up here and wear buttons that would say, marijuana is not medicine. They don't wear those buttons anymore. You know why? Because the National Academy of Sciences reviewed 10,000 abstracts and in 2017 said there is conclusive proof that cannabis can provide relief for neurological disorders, for chronic pain, for things of that nature. So those buttons got retired. There's a bunch of buttons somewhere. They don't wear them anymore because they don't make any sense. It's not true. The second story, anecdotally, and I have hundreds of these, but I picked out a couple because I'm not going to take up a lot of time. But I want to read this one that I got texted to me. Senator Davis, I saw that you are pushing for medical cannabis use in South Carolina. I need to know if there is anything that the public can do to support your efforts. I am 45. I have had around 20 operations in the last 12 years, and I am in constant pain. I have an autoimmune disease, a pelvic floor dysfunction, constant muscle spasms. I refuse to take opioids and other addictive medications, although when it gets bad, I have to take a muscle relaxer to calm it. My husband and I read about the different strands of cannabis and how they help with chronic pain conditions. We decided to travel to a state that has legalized cannabis so I could try it. I do not like the feeling of being high, or not myself, so I tried the lower strength and one or two others. Eventually, I found one that worked for me. I had a week of almost completely pain-free days. It was magical and encouraging. Of course, when I came home, I was back to my daily pain routines. We have considered moving states, but both have parents in Charleston that are up in age. We also have our jobs, home, and children here. I apologize for this long message, but I'm encouraged by what you are doing and want to try to help. Again, an anecdotal story, but I followed that up with a phone call with her. She's not lying. Margaret Richardson's not lying. But again, I went to peer-reviewed medical evidence. Because look, we've had medical cannabis laws in the United States dating back almost 30 years now, starting with California. We have a robust body of medical empirical data to support conclusions. This is no longer anecdotal. This is documented It is medicine. The National Academy of Sciences recognizes it. Medical journals throughout the country recognize it, and particularly in regard to opioids, the question that Amy in this last message I read, conclusively, it was determined that there is a direct correlation between the availability of medical cannabis and the diminution of opioid use. I mean, there's a direct correlation. It's 1-to-1. In states where you've had medical cannabis made available for chronic pain, people have used that as a substitute to opioids, have gotten off opioids and onto something that provides the relief in a much more benign way. Studies have been done in that regard. With Medicare Part D populations, a study was done, and opioid mortality rates decreased by 20% in states that had medical cannabis laws. Another study, a more recent study, was done that showed that states with medical cannabis laws had 24.8% lower mean annual opioid overdose mortality rates. So, again, there is not only evidence that opioids can be replaced by marijuana in regard to providing chronic pain relief, but there is also evidence that it reduces opioid-related deaths. So again, I start with those anecdotal stories because they're compelling, but I don't stop there. I go into looking at the body of empirical data and present to you what I found. And that's an important point I want to make, is because a lot of medical cannabis bills in this country, and I mean, we have 38 states in the District of Columbia. They're not all the same. Some of them are very loose. Some of them have a long list of qualifying conditions. Some of them don't require a doctor to authorize on the front end. Some of them don't require a dispensary to dispense or a pharmacist to dispense on the back end. Ours does. This bill I represent to you, I went into this wanting to come up with the most conservative medical cannabis bill in the country that empowered doctors to help patients, but at the same time tied itself to science, to addressing conditions for which there's empirically based data saying that cannabis can be of medical benefit, and to do so under the most controlled circumstances, with physicians being the gatekeeper, physicians being the ones who have to have an in-person diagnosis made before they can authorize the use of cannabis by one of their patients. It's no surprise that given what I've just told you, that professional medical establishments endorse medical cannabis. The American Academy of HIV Medicine, the American College of Physicians, the American Nurses Association, the American Public Health Association, the Leukemia and Lymphoma Society, the National Multiple Sclerosis Society, the U.S. Pain Foundation, the Epilepsy Foundation. I can go on and on. But the people who make a living in this space, medical professionals, have all opined this is something that should be made available to patients if a physician thinks it's in their best interest. And for those of you in the chamber who I heard during COVID about medical freedom, about the rights of patients to try things like ivermectin and things that the CDC said, the federal government said, don't use that. That's not what you should be doing. There were people in this chamber that stood up and said, no, medical freedom demands that you let a patient do what that physician thinks is in that patient's best interest. That is a bedrock principle, that relationship between a physician and a patient trumps what either the federal government says or the state government says. I heard that over and over and over again, Senator from Orangeburg. Over and over and over again. I still hear it. But I don't understand the cognitive dissonance that it's okay for a physician to prescribe off-label or to let ivermectin if the physician thinks it's in the patient's best interest, even though the federal government says no. But by the same token, if a physician wants to authorize the use of cannabis, that all of a sudden we say, no, you can't do that. When does medical freedom end? When do politicians take over from physicians in regard to what's in a patient's best interest? That is a distinction that I don't think can be defended. I look forward to hearing it. I look forward to hearing that defense, but I don't think it can be defended. Now, again, I mentioned a little bit earlier about the National Academy of Sciences, and I want to gloss over that because that's an important part of the case I want to make here. Now, the National Academy of Sciences is a private, nonprofit society of distinguished scholars established by an act of Congress signed by President Lincoln in 1863, and it is charged with providing independent, objective advice to the nation on matters relating to science and technology. Scientists are elected by their peers to membership in the National Academy of Sciences for outstanding contributions to research. It's a very exclusive association. It is committed to furthering science in America, and its members are active contributors to international scientific community. Approximately 500 current deceased members of the society have won Nobel Prizes, proceedings of the National Academy of Sciences, and is the premier international journal for publishing the results of original research. Now, I say all that to say this. The National Academy of Sciences, back in 2017, after reviewing 24,000 medical abstracts, after exhaustively examining the empirical data in this space, they found that there was conclusive proof, the highest degree of proof. There are 5 levels, conclusive being the highest, conclusive proof that cannabis is medically effective for the treatment of chronic pain, for treatment of chemotherapy-induced nausea and vomiting, for multiple sclerosis spasticity symptoms and neurological disorders. So let's not be under any illusions here. This has been established and is accepted and is acknowledged in the medical community. Next. I think I've answered the question of can the state act, and I've tried to lay out the reasons why I think it should act, okay? Because if you have something that can provide relief, I think that we should act. I believe that. I believe doctors should be empowered. I believe doctors ought to be able to do what they believe is in their patient's best interest. The question then becomes, how specifically should we act? How should we go about making safely available to patients medical cannabis that can help them? And so what I'm going to talk about now is this bill that is the result, the culmination of 10 years worth of work, of over 20 subcommittee hearings, 3 intense weeks of Senate debate. This is my 16th year of the Senate. I can't think of a bill that has undergone more testimony, more scrutiny, more debate than what's before us here right now, which is why it got passed 2 years ago, 28-16, with a majority of Republicans voting for it, okay, because that diligence had been done. This work product is something that has been so thoroughly vetted that I could stand here for hours, but I won't, answering questions about it, because what I've done throughout that 10-year period is I've gone to the South Carolina Medical Association and said, how can we make this bill better? And I've incorporated what they've shared with me. I have gone to law enforcement and said, what is it about this bill that concerns you most greatly, and what can I do to alleviate it? They said their number one thing was they don't like the idea that you burn flower. They don't like smoking of it, because if people consume it medically that way, which is frankly the most effective way to consume it, then they can't distinguish between those who are consuming marijuana legally, medically, and those that are consuming it recreationally. And so I put into the bill, much to the consternation of a lot of the grassroots members out there, no pun intended, that you can't burn flower, that you can't smoke it. It's got to be limited to a topical application, to something you take orally, or to something that you vape. Made that concession in order to address what law enforcement said, quite frankly, was their number one concern. I also, my friend from Ori, who is an incredible adversary in this. I don't want to say adversary. I mean, he's a skeptic, maybe I could say that. But, and I welcome it, because good legislation arises out of being challenged on your assumptions. It arises out of looking at legislation and picking it apart as best we can to avoid unintended consequences. And I don't know if the senator from Ori remembers, but when he talked on this bill a couple years ago, he was up here for, I think, 3 hours, and I took copious notes, 24 pages of them, in fact, of all the syntax and grammatical and the way I characterize things, and took notes. And then we sat down, and over a 3-week period from Senator from Orangeburg, we took up amendment after amendment after amendment, and one after another, I put check marks by all the ones that we went through. And I remember when he got done speaking from the well, I said, Senator from Ori, I'm taking notes here. I want to make sure that you have gone through this bill in its entirety and pointed out to me the things that cause you concerns. And he says, well, I think I have. So I got to work. And then over a 2 or 3 week period, we adopted amendments offered by several other members as well, and we got a bill passed. So that's all by way of background on how we got here with this legislation, and I want to speak to the vetting process a little bit. Now, as to the bill itself, the most important aspect of the bill, and I'm not going to go over all of them, but I do want to go over some of the more important aspects of it. The most important aspect I would submit to you, and I don't know if it's the same as on the computer printout, but it's on page 10 of it being printed, and it's section 44-53-2050, which talks about the extraordinary level of due diligence that a physician must go through before he or she can authorize a patient to access cannabis to address a medical condition. Because I am aware of something that the Senator from Ori, Senator Embry, passed out today, this Wall Street Journal article about how marijuana can be dangerous. And it can be dangerous. You're not going to see me standing up here saying marijuana can't be dangerous. You're not going to hear me say that it can't be abused. You're not going to hear me say it can't cause, as this says, complications in pregnancy. You're not going to hear me say that it can't take an underlying anxiety or mental condition and exacerbate it and make it dangerous, something along the lines of what's outlined in this article here. This actually makes my point. This is why you have to have such thorough diligence on the front end with a physician sitting down with a patient, because this is not something to be taken lightly. This is not something to be glossed over. This is not something to be minimized. This is something that you are consuming that interacts with your brain, interacts with your body, interacts with your vital organs. And of course, anytime you do that, anytime you take some sort of medicine or substance, you should do so under the care and recommendation and supervision of a doctor. Okay? This isn't a recreational bill. This is speaking to the dangers associated with normalizing cannabis so it's seen as just like consuming alcohol. This is talking about the recreational use of marijuana. And I think it makes some valid points. But let's be clear, that is not what we are talking about here. We're talking about a medical bill and empowering physicians. And more than that, of the 38 states that have done this, this is by far the most restrictive. And the first reason it's the most restrictive is because of the extraordinary amount of diligence that a physician has to do on the front end before a patient is authorized and given a card or given a certification that they should access medical cannabis. And again, I'm just going to talk about, I'm going to go over some of it here. It has to be a physician, first of all. Okay, it has to be a physician. It has to be a medical doctor. Second of all, it has to be a medical doctor authorizing a patient in whom there is a bona fide relationship. We're not talking about drive-by doc shop. We're not talking about any of that. There's got to be a bona fide relationship defined in here, defined in the legislation. The physician has to say in this statement, before they authorize the cannabis, that the physician has consulted the prescription drug monitoring program for the patient, the control of substance abuse prescription history for that patient. The physician has to conduct an in-person evaluation and collect relevant clinical history, has to study and debate whether or not the patient has a history of present illness, the social history, the past medical and surgical history, alcohol and substance abuse history, family history, physical exam, documentation of therapies with adequate responses. I mean, it goes on and on and on in regard to the diligence. And then, after all of that, the physician has to develop a written treatment plan which states that conventional medications have not been successful. Okay? In regard to authorizations like for chronic pain and PTSD, which by their nature are more subjective or can be more subjective. And there are some concerns that some raised about, well, somebody can just walk in and say they've got chronic pain, so therefore give me some cannabis. Or I've got PTSD, so therefore, doctor, authorize me to access some cannabis. So we drafted amendments to this bill which says that if you are being authorized to use cannabis by a physician because you've got chronic pain, the physician has to attest in writing that there is objective proof of the etiology of that pain, such as a diagnostic test, which may include x-rays, computerized tomography scans, or magnetic resonance imaging. So in other words, it is not enough for the patient to simply say they have chronic pain. The physician has to be able to objectively view the etymology of the underlying cause of that pain. Similarly, in regard to PTSD, it is not simply enough for a patient to say, I have PTSD. There must be documented instance of a traumatic episode in that patient's history before it can be authorized by the physician for that particular medical treatment. So there's got to be some underlying objective proof of a traumatic experience. So that was an effort, unlike other states have done. The other states have just said chronic pain, PTSD. We've gone the next level down and said there's got to be objective underlying proof in the etymology of that. I would just invite you to look at the 4 pages that are outlined of what a physician has to do to certify and then to sign his or her name under oath at the risk of losing their medical license and being disciplined that's in this bill. Because it is so important that there be that gatekeeper on the front end so that there's integrity to this process and it doesn't become a joke, okay? I've taken this very seriously to make sure that it is something that is very, very stringent. Now, in regard to, and this is something that I want to thank the Center for McCormick for bringing to my attention in regard to cannabis-induced psychosis, or there's a book called Have You Told Your Children? And there are instances where if cannabis is used by someone who has an underlying mental disorder or anxiety or underlying medical condition, it can exacerbate it into the very thing that is noted in this Wall Street Journal article. So the bill says that in instances where a patient has a history of substance use disorder or a co-occurring medical health disorder, there has to be a required specialized assessment by another expert in regard to psychiatric addiction or mental health specialist. Needs to be brought on board. So in other words, I am mindful of the fact that nothing you put in your body that's a medicine is always harmless or is always beneficial. There are going to be instances where it can exacerbate problems. This bill identifies those instances and requires additional specialists to become involved when they present themselves. I'm going to speak in fairly cumulative fashion about the remainder of the bill, and there are specific things in here that specific senators wanted, and I'll try to touch on all of them, but I'm not going to be exhaustive in that regard because it's 65 pages worth of legislation that we've gone over for 3 weeks already, but I do want to hit on some of them. First of all, it is a felony, punishable up to 5 years in prison, if some patient wants to access marijuana for medical purposes and turns out to be lying, or turns out to have committed fraud, or turns out that they just want to get the marijuana to divert it, or to use it recreationally. It makes that a felony. Now, to me, if somebody wants to consume marijuana recreationally, why would they go through the trouble of going to a doctor, getting a written certification, committing fraud, subjecting themselves to a felony conviction, and buying cannabis for a much more expensive price from a pharmacist because it's going to be more expensive than just go on the street and get it, which is what they're doing now. So let me make this point, Seth from Orangeburg. We're not introducing evil into the Garden of Eden here, okay? This isn't the serpent tempting Eve with an apple, okay? We have kids smoking marijuana now, recreationally, and all too often we have them smoking marijuana that's laced with fentanyl and they're dying. Okay, so this idea that we're opening a Pandora's box and somehow going to introduce recreational marijuana use in South Carolina, to me is naive. To me, it's naive. What we're doing is addressing a situation like with Margaret Richardson. And I'm serious about this. And I mean, let me speak to my friend, Senator from Charleston, Senator Campson. What do I say to Scott and Margaret Richardson when they tell me about this condition she has, where her face feels like it's on fire, and she screams like an animal in pain, and none of the prescription drugs she's given helps? The extensive surgery she hasn't helped. But what does help is taking one puff on that marijuana cigarette, on that joint, and the cannabinoids interact with the endocannabinoid system, and it alleviates that pain. What do I tell them about what she should do? Because right now she buys it illegally. Right now she has to go out, she has a dealer. Okay? And that can't be the compassionate response. It just can't be. I mean, her physician wants her to have it. Her husband wants her to have it. She desperately needs it. And she's been up here begging for us to authorize it. And she wants to come up with a tight bill. She doesn't want it to be abused. But we got to figure out a way to make it available to her. We have to. We can't just simply say to her, you're on your own. I mean, I can't do that. I mean, they're my constituents, but they're also my friend. And so that's what drives me. So what are some other things we have in this legislation? Well, I'm always fearful of unintended consequences. Maybe some of the opponents of this bill are correct. Maybe some of the societal ills that I say aren't to be worried about, maybe they come to fruition. So what's one way of addressing that? Well, I put in here automatic sunset clause. It sunsets automatically after 8 years. After 8 years, it goes away automatically. And if proponents want it back, we got to file the bill again and take it all through the legislative process again with 8 years worth of experience to either support or oppose it. So I built that in there because I don't want unintended consequences. I want to pass a bill that is helpful. But in the event it isn't, I don't want to put the burden on those that feel like it could be dangerous. I don't want to put a burden on them. I want to put the burden on those that are making the case for it. That's why it automatically sunsets. Now, in regard to some who may still have lingering concerns about federal preemption, that somehow the federal government, even though the Controlled Substances Act doesn't preempt the field in express terms or implied terms, even though the budget every year contains a rider that says to the DOJ, you can't spend any money to interfere with medical marijuana laws, even though you got IRS regs and Treasury regs, everybody acting like this is something that's fine and accepted. But even then, I put in here at the request of some opponents that if this is challenged in court, and if a federal district court enjoins this law, then it automatically sunsets. It automatically goes away without any further action. I don't want there to be any concerns by anybody in here who feel like voting for this bill is somehow going to be voting for something that's contrary to federal law. I don't think that it is, but in case it is, it goes away and has no force and effect. Okay? I built that into this bill. I could go through the rest of it, but the conditions for which it's authorized. Let me touch on that for a moment, because I did talk about how they were limited in nature, and I think we need to touch on that real quick. And I don't want to be too long. I'll be mindful of the sentence time. It's been narrowed down to 12 qualifying conditions. There's 12. There used to be a lot more. There used to be more than that. But in looking at this and challenging myself on this and in challenging the advocates, I said, I don't want to put forth anything in regard to a qualifying condition that's simply anecdotal, that doesn't have underlying peer-reviewed evidence to support the proposition that it could be medicinally beneficial. And so it's limited to these things: cancer, multiple sclerosis, neurological diseases, PTSD, subject to the evidentiary requirements that I talked about earlier about evidence of a traumatic condition having an incident occurring, Crohn's disease, sickle cell anemia. Senator from Richland is particularly interested in that one. Ulcerative colitis, wasting syndrome, autism, nausea related to end-of-life or hospice care, chronic medical condition causing severe and persistent muscle spasms, or any chronic or debilitating disease or medical condition for which an opioid is currently prescribed based on generally accepted standards of care, i.e. chronic pain primarily. Each one of those 12 qualifying conditions has a substantial body of peer-reviewed empirical evidence saying cannabis can be medically efficacious. It is not anecdotal. It is nailed down. I promised this body I was going to come up with a conservative bill, so I limited the conditions for those for which there is proof. Now, there is a medical cannabis advisory board that is established that allows that list of qualifying conditions, the 12, to be expanded in the future based on the advice and recommendation of this commission. And let's talk about who's on that commission. One licensed medical doctor authorized to practice medicine who does not issue written certifications for cannabis. One licensed medical doctor authorized to practice medicine who does issue written certification for medical cannabis. One licensed doctor of osteopathic medicine who writes the certificates. One licensed doctor of osteopathic medicine who does not. One licensed medical doctor who is board certified to practice addiction medicine. One research scientist with expertise in the field of cannabinoidal medicine. One licensed pharmacist who does not dispense a cannabis product. One licensed pharmacist who dispenses a cannabis product. And then one qualifying patient and one parent of a minor qualifying patient. So overwhelmingly, you can see the members of this commission are medical doctors, medical physicians, both those who authorize cannabis use and those who do not. There was some criticism initially, which was fair, that this was not weighted toward the medical community the way that it is now. I represent to you that it is weighted in that way now. The next thing I would like to talk about is in regard to talked about the written certifications, talked about the medical advisory board, talked about physician's due diligence, which goes on for 4 pages and is exhausted and must be signed under oath by a physician at the risk of being stripped of his or her license. Let's go to the pharmacist section. There are 4 or 5 states right now that require a pharmacist be involved in the dispensing of medical cannabis. South Carolina, this bill, we become one of those states. Now, Georgia was recently challenged in regard to a pharmacy program that it had, Senator from Orangeburg, and I want to talk about this for a moment because I think it's an important distinction to be made. What Georgia attempted to do was to say to pharmacies like a Publix or a Walgreens that dispense controlled medications that they could also dispense cannabis. And the DEA said, we have jurisdiction over these pharmacies that dispense controlled substances. We have supervisory authority, and we're going to enjoin that. What they have not enjoined is what's in this bill, which says that it has to be a therapeutic cannabis pharmacy. Okay, it can't be involved with a pharmacy that dispenses controlled substances. It has to be a separate facility that solely dispenses cannabis. So it's not subject to DEA supervision and regulation. It doesn't fall within that jurisdiction. So I want to be very clear about that because, and this was debated, and Senator from Spartanburg, Senator Kimbrell will remember this, that during the debate 2 years ago, we spent several days working with the South Carolina Board of Pharmacy, representatives and attorneys for the South Carolina Board of Pharmacy, and carefully drafting a section that conformed with the law that the other states have passed that has not been interfered with, not been enjoined, not been interrupted by the federal government. So I want to be very clear that the pharmacy system that we have set up, the pharmacist dispensing that we have in this bill, is in line with the states that have programs that have not been interfered with. Don't conflate it with what happened in Georgia. Georgia went too far. Georgia went to and wanted mainstream pharmacies like Walgreens that are supervised by the DEA because they issue controlled substances. Georgia wanted those pharmacies to dispense cannabis products. So I wanted to make that distinction. It was important to several members of this body that not only a doctor be involved on the front end, a very stringent due diligence, a very stringent in-person examination before an authorization can be made for certain limited conditions. They also wanted a medical professional on the back end, okay, on the dispensing, because That way you have an information loop. That way you've got a pharmacist who is interacting with the patient down at that local level and communicating information back to that physician who has to subsequently review that patient's history and then recertify them on an annual basis, okay? So it's a constant medical loop there. And that's important because the way cannabis works, the way cannabis can address an underlying problem is going to vary from individual to individual, okay? A certain individual may have an underlying problem with their endocannabinoidal system that requires a high concentration or ratio of THC, which is a psychoactive component of marijuana, to CBD, which is non-psychoactive. Others may require to have a higher CBD ratio. And it's going to take a little bit of give and take at that pharmacy level to figure out what ratios will effectively address that patient's condition. So it's very important, Senator Cromer, that we have a pharmacist who's used to interacting with patients and counseling patients and listening to patients. It's important to have them involved in the process. It's equally important that they be conversant with medicine in regard to cannabis. So we have continuing education requirements for both doctors who want to authorize use of cannabis and pharmacists who wants to dispense it. They have continuing medical education requirements in regard to cannabis medicine, okay? So again, one of the benefits of having a bill that has gestated over a 10-year period is that it is very mature, that it is very well thought out, that it takes into account everything people have said in here, and we've made it a much better bill. I think when this bill passes, and I hope it does pass, it's going to be the template for any state that truly simply wants to empower doctors, empower patients, and doesn't want to go down the slippery slope to medical. I think it can actually be used by several states that maybe regret their decision to allow recreational use, or they may be looking to tighten up their medical laws so that it becomes something more stringent. This could be that example. That's one of the advantages of having a bill that's undergone 10 years worth of scrutiny, okay, because it's a bill that can then stand up. But having said that, let me say this, and this goes back to Senator Campson, one of our favorite economists, Friedrich Hayek, about a famous essay called The Knowledge Problem, that as hard as experts may try, that as hard as they may try to divine what's going to happen in the future, that that can never be a substitute for what actual experience out there in the world teaches us, because you've got knowledge that's dispersed among millions of people. And so I've tried the best I can to come up with something here that I think works. But a corollary to that knowledge problem that Hayek references is we've got to be nimble, and we've got to have multiple bites at the apple to make sure we get it right, which is why this bill contemplates DHEC, or the Department of Public Health, if as we're implementing it, they have to promulgate regulations to implement this broad outline, which come before us again. So we're going to get another bite at the apple in regard to how DHEC is going to implement this, because DHEC is going to be out there working with medical providers, working with equipment and manufacturers and suppliers, talking to others and bringing back professional recommendations to us in the form of regulations that we'll look at again, okay? And it contemplates that undergoing iterations as time goes on, because as this space matures and as it becomes more of a part of everyday life, we're going to recognize things. In fact, I'm certain of it. Things in here we got wrong. There are going to be things in here or assumptions I made that were just simply wrong, which is why we built into it some broad discretion within outlines of what DHEC should promulgate in terms of regulations, because we need to be nimble. We need to be a little bit humble in terms of we can't anticipate everything. Same thing in regard to Board of Pharmacy. This bill requires the Board of Pharmacy to promulgate regulations under which a pharmacist is going to be running a cannabis therapeutic pharmacy. That may take several iterations before we actually get it right. Senator Cromer, I may be trying to figure out how it's going to work in practice. It may turn out to be something entirely different. Built into this bill is the ability on that administrative level to come back before us on repeat basis with regulations that we have to approve. And we're going to look at them again. We have to approve. And if we don't like them, we send them back. We'll ask them to be withdrawn with recommendations. So I say all that to say this. This isn't the end of the matter. Okay, this begins the process. We're going to have subsequent opportunities to see how it actually works in practice. That's by design in here. This is not so overly prescriptive to where agencies can't adapt to what realities are on the ground, both in regard to the Department of Public Health and in regard to the Board of Pharmacy. So I wanted to make that point. Talked about PTSD, how you have to have underlying evidence of a traumatic experience. There has to be, for instance, here are the examples of that evidence. Proof of military service in an active combat zone, or that the person was a victim of violent or sexual crime, or that the person was a first responder. Those are the underlying empirical conditions that can support a PTSD authorization of the use of cannabis. Again, trying to take something that may be seen as inherently subjective and making it more objective so that it is not abused. It was important to the Chamber of Commerce when I met with them that employers be allowed to have drug-free zones if they want to. That somehow this legislation wasn't going to take away their right to control their work environment. So it is built in here, says that nothing in this act shall preclude an employer from having a drug-free workplace environment. There is no statutory right to either consume cannabis on the premises or to be under the influence of cannabis if your employer does not want that. That concession was made to the Chamber of Commerce. In regard to local government, local zoning, local governments can zone this out if they want to. Now, this is something that got a lot of pushback in the grassroots community. They were saying this is medicine, and so local governments ought not to be able to use land use regulations to push back and to deny it. But again, in an effort to get consensus, and because several members were concerned about some towns may not want this, that was a concession that was made. So that police power rests with local governments to preclude medical cannabis establishments within their jurisdictional boundaries. There was also some concerns that there are certain occupations that by their very nature are so dangerous that we don't want somebody under the influence of cannabis even for medicinal purposes, okay? So we said in here that the following individuals cannot be under the influence of cannabis even if it's medicinally authorized. If it involves the carrying of a firearm, requires a law enforcement credential, requires a commercial driver's license, charter boat license, or a pilot's license, involves the operation of trains, buses, or any form of public transportation, or involves the operation of heavy machinery. Took those off the board. If you've got those kinds of jobs, you can't be under the influence of cannabis, even if it's for a medically documented purpose. It's just not allowed by this law, and you don't enjoy the protections of this authorization. It talks in regard to who can serve in medical cannabis establishments. The employees, those that work in a processing facility or work in a grow facility or work in a therapeutic pharmacy. They have to undergo a state criminal records check supported by fingerprints by SLED and a national criminal record search supported by fingerprints by the Federal Bureau of Investigation. And if they don't pass, or if it turns out that they have been subject to an arrest, a conviction, a pending warrant, or other criminal or civil indictment, then they can't be authorized to be an employee in a medical cannabis establishment. Looking through here to hit some of the other higher points. Again, the smoking of flower, the burning of flower, that is prohibited. This is an important one, too, in regard to DUIs and in regard to driving under the influence. It says as follows: nothing in this article may be construed to prevent the arrest or prosecution of a qualifying patient for reckless driving or driving under the influence of cannabis products if probable cause exists. The mere presence of cannabis, sorry, I lost my place. If a qualifying patient refuses to submit to a blood sample test, then the qualifying patient's privilege to drive is suspended for at least 6 months, and his registry card is suspended for 6 months. So much like when you're pulled over for DUI, if you refuse a breathalyzer, you lose your license. Here, if you're pulled over for reckless driving, in this case, maybe under the influence of cannabis, if you refuse a blood test, you lose your driver's license, you lose your registry card. We tried to put them on par. We tried to put them on the same plane as those driving under the influence of alcohol. The language in regard to blood sample was put in there because it is difficult, if not impossible, to detect the use of cannabis through a breathalyzer. And so only a blood test would be the equivalent in that regard. So that was added. Now, I'm sure that's going to cause some problems over the House. I've heard that's already going to cause some problems with some criminal defense attorneys over in the House. But I included that because valid points were made about concerns about individuals driving under the influence of cannabis. But let me tell you this, and this may be counterintuitive, Senator from Richland. Let me tell you this, Senator Jackson. You've heard it said that if we authorize the use of medical cannabis, that there's going to be more individuals on the road driving impaired. Did you know that there has been exhaustive studies, and again, we have decades worth of experience now with medical cannabis, that the incidence of impaired driving rates, the incidences of car vehicle-related deaths are down in states that have medical cannabis laws because marijuana and alcohol are often seen as substitute goods, okay? So it's counterintuitive to think that if you authorize medical cannabis that the accident rates go down, but that's empirically true because you have less people driving under the influence of alcohol when you have medical cannabis laws, because a lot of people treat their symptoms through drinking. I mean, and that's Department of Transportation studies in that regard. So this nomenclature or this argument that somehow we're making our roads more dangerous by authorizing medical cannabis is not borne out by the empirical data. That is just a false talking point. In regard to landlord-tenant, my friend Seth from Greenville is not here, but he had some questions in regard to under what circumstances can a landlord deny or disallow the use of cannabis. And it can be denied by a landlord in the following instances. If the tenant is a roomer who is not leasing the entire residential dwelling, if the residence is incidental to the provision of medical, geriatric, educational, counseling, religious, or similar service, if the residence is a transitional housing facility, or the residence is a dormitory affiliated with an educational institution, which is a question he asked me about dormitories in colleges, you can prohibit the use of cannabis products in those settings. So I wanted to emphasize that particular point. We've already talked about how an employer has workplace sovereignty and can have a drug-free workplace if that's what it chooses to do. There is no statutory right to go to work under the influence of cannabis, even if it's medicinal. There were concerns 2 years ago. There were incidences of vaping incidences, or people who became injured while vaping, or vaping incidences had misperformed or malperformed. This has entire sections in regard to how it must be vaped, how to vape safely, things that you can't do. There's an entire section on that if you want to read it.
Senator from Pickens, what purpose do you ask, sir?
Are you yielding now? Would you?
Oh, sure.
Yeah.
Sure.
Senator Yield, question. Senator Yield for question.
I want to go back to the employment issue because I've got a commercial driver's license, and I'm subject to a random drug test at any given time. So if I've got that, does this waive the requirement for that drug test?
No, if you're a commercial driver, let me pull that out here real quick.
Not only commercial driver's license, but other places where you have employment screening or drug screening.
Yeah, the way this bill is worded, Senator Pickens, is if your employer wants to have a drug-free workplace, if your employer wants to have screening, if your employer says you can't be on the premises on the influence of cannabis, nothing in this bill says an employer can't say that.
Well, there's a difference in being under the influence and having it in your system. Because somebody can...
They can't have it. I mean, if an employer wants... I mean, this is worded so strictly, because the Chamber of Commerce wanted this. It is worded in this way, that if an employer wants to have as a policy that they don't want to have employees on their premises with any cannabis in their system, they can have that policy if they want it.
Thank you.
Senator from Anderson, Senator Cash, what purpose do you rise, sir?
Sure, I'll yield.
See if this senator would yield for some questions, if
Sen-
he's
Senator
ready for
yields.
questions.
Senator
Yes.
yields.
Senator, I have got a side-by-side of the bill with S-150. And without going into every change that's been made, I would like to go through the changes
Sure.
that stick out and just get some brief explanation from you here and there to just illuminate what differences there has been made between what we're dealing with today and what we had passed 2 years
That's fair.
ago. Would that
Sure,
be
that'd be helpful. I think
acceptable?
that'd be helpful.
Do you have the side-by-side yourself?
I don't, but I'll be able to answer your questions.
I'm sure you will. All right, Senator, the first difference I see here that's somewhat notable is in the cultivation center. And basically, I think the difference is 2 years ago, you could not have a multi-tiered, multi-level facility. And this allows for a multi-level facility as long as you don't exceed a certain square footage. That's definition number 7, cultivation center.
We know what section it is. I'm sorry. I remember.
Well, it's back at the beginning under definitions.
Yeah, I can remember that was something I think the Senator from McCormick raised, and the concern was the volume of space that was being used for commercial growing. And I think the point being made was that if you tiered it up, you could increase the square footage. And so I think what we put in there is a maximum square feet. So I think that's what the intent of the amendment was to get at the size of the particular cultivation establishment.
I would agree. And Senator, the next difference I see here, and this is one of the more substantial changes, is definition 17, integrated operator. This is something new.
Yeah.
It's an operation licensed to cultivate, process, package, transport, and operate one or more therapeutic cannabis pharmacies. So I think the bill 2 years ago, you simply couldn't do that. I mean, it was kind of the grower couldn't be the seller, if I'm remembering correctly.
It was silent in that regard. But what this says, you're correct. What this says is that when DHEC issues or opens it up for applications, that there be a mix of production models, some being horizontal in terms of you've got a grower, a processor, and a dispenser all being separate entities, but then in other instances you have those means of production vertically integrated. And the reason it was put in there so there's a variety of production models was so that we had the ability, either through regulations or through reauthorization of this bill after it sunsets in 8 years, to determine which means of delivery was most effective to get product to the consumer and most easily regulated by law enforcement. So the idea was, and this is the way that I think of this, it's almost like an 8-year pilot project. And what we want, I think, during that 8 years is robust experience with various business models, because in 8 years, we're going to have to either reauthorize this or not reauthorize it. And I would like us to be in a better position in 8 years. I don't know if I'll be here in 8 years. I mean, but maybe I will. But I'd like us to be in a position to make an informed decision. So that was the thinking behind that. I don't have a preference for one or the other. It goes to what I said to the Senator from Charleston earlier. I can't predict in advance what's going to be the most efficient way of generating product and getting it to consumers. I don't know which means of production is going to be most easily monitored by law enforcement. It may be easier for them to look at it all in one place, or it may be it's better to have it spread out among horizontally different businesses. I don't know, but the thinking there was, before we were silent. We didn't say it was allowed. We didn't say you had to give a mix. We didn't say anything. We just simply said these are the number of centers, and these are the number of processors, these are the number of dispensing, and we didn't say anything about whether or not they could be wholly owned or vertically integrated or not. You're right. It's different here. It does direct DHEC to provide a variety of models for that reason.
All right, so when you refer to the number, you'll remember that we had 15 cultivation center licenses, 30 processing, 4 transporter, 1 therapeutic cannabis license for every 20 pharmacies, 5 independent testing laboratory licenses. Now, the insertion after that is new is that the number of integrated operator licenses recommended by the commission is being sufficient to enable the department to analyze, assess, and compare the various business models. So I don't know if it's so much as of concern. It seemed like originally you were very specific in how many centers of doing various tasks were going to be allowed.
Yeah.
But when we've added this integrated operator thing, it's just up to the discretion of the commission at that time. There's no real given number, so.
Well, you still, I think you still have a defined universe of the number of licenses that can be issued. It just may be in some instances that those licenses may be integrated in a single operator, but you still have the same finite number of licenses that can be issued. Now, let me just say this. I'm not wed to any of those numbers. Okay, those numbers are based on what other states have done, and I tried to take the mean and the average and then figure it based on our population of 5.1 million and come up with a number of grow centers and processing centers and pharmacies. But I'm open to anybody else's thoughts in that regard. Be honest with you, I don't consider that to be material. Well, it's material, but I don't consider that to be something that I'm not open to being persuaded one way or the other. It is. I mean, if some people want less because they think it's sufficient and more easily regulated, or if there are others that think maybe there needs to be more because we want to have more access to patients, I'm open to either argument in that regard. I've just come up with those numbers based on what other states have done. I've got no other reason than that.
Right, and I accept the math based on other states. So if I understand what you're saying, when you get to the point of talking about the number of integrated operator licenses, if that person is going to be a cultivator, a processor, a transporter, if he's going to be all those things and he's using up one of those licenses,
That's correct. That's correct.
The way that you envision this?
Absolutely.
It's not all that plus however many integrated people in addition with all these other licenses.
The first part is correct. And to the extent that that's not clear, I would accept an amendment to make that clear. But the intent would be that if a vertical operation has 3 or 4 licenses associated with it, that exhausts the allowance that is authorized in this bill.
No, that's helpful. All right, on definition 21, the medical use definition.
Okay.
In the original bill, medical use was definition 20, and it had subpoints A and B, which have been removed from the medical use definition. And I read it and tried to figure out why A had to do with the extraction of resin, and B just said simply smoking. And that's just, A and B are just gone from the definition now, and I'm not quite sure why they would have been removed. So
let me try to read it here real quick. So right now it says medical use means the acquisition, administration, possession, preparation, storage, transportation, or use of cannabis products or paraphernalia used to administer cannabis products to treat or alleviate a qualifying patient's debilitating medical condition or symptoms associated with a qualifying patient's debilitating medical condition, and includes the transfer of cannabis products from a designated caregiver to a qualifying patient whom the designated caregiver is authorized to assist. Now, what was in A and B in 150 that were excised? What did it say?
Well, it was medical use does not include the extraction of resin from cannabis by solvent extraction, and does not include smoking.
I think, well, subsequently in this bill,
tighten this up?
We can add does not include smoking if we want to, but it's said in 2 other instances in the bill that you can't burn flower. But I'm happy to include that prohibition expressly in the definition as well. I think it was deleted because it's redundant, because it appears in other sections in the bill.
That would make me feel better about it.
Okay?
It's my understanding from reading both bills and comparing them that if someone goes to the cannabis pharmacy, they cannot walk out with, for lack of a better term, the leaf marijuana in a form that they could then go roll it up and smoke it. Is that correct?
That's correct. It's got to be topical application, something you take orally, a tincture, or it can be something in oil you can vape. But you cannot have flour, which you could then roll into a joint, or that we would think of as a joint, and burn flour. That is not something that is either authorized for use, nor is it allowed to be dispensed by a pharmacist under this bill.
So if they're going to vape, and that's, I'm assuming, where the inhalation terminology comes from, right? Mm-hmm. What are they vaping from? What do you start with if you're vaping?
There's a cartridge, or there's a way that you you put the oil in the cartridge and you then vape it. I mean,
so it's an oil.
It is. It's an oil.
Okay. Moving over to definition number 31. Smoking or smoke means the inhalation of smoke caused by the combustion of raw cannabis or cannabis products that causes burning.
Okay.
The prior definition was smoking or smoke means the inhalation of smoke caused by the combustion of cannabis or cannabis products that causes burning. So the word raw has been added there, and I'm assuming that when you add raw, you're getting back to the leaf. Is that
to the flour?
Why you've added that, the flour?
Yeah, flour,
Is that what you're going to want to call it?
Mm-hmm. See, a lot of this, let me make this observation. When we amended this bill on the floor, particularly the last couple of days of session, the amendments came quickly, and they were drafted very quickly by staff. And so in a lot of instances, in looking at it and then putting this bill forward, I tried to take the substance of those amendments, but to put it in a clearer form without changing the underlying intent. So it's not my representation to you that it's verbatim, but I would represent to you that in substance it is materially the same, and the only changes that were made were attempts by me to further refine language that was drafted very hurriedly on the fly in the Senate. So that's the reason for a lot of these nomenclature changes.
I understand. Let's move forward to section 4453 2050.
Yes, sir. Physician due diligence.
Under down towards the bottom of my page, it's talking about the risk of cannabis, advice about the potential risk of the use of cannabis products to include the risk of cannabis use disorder is the first one there. Do you see that?
I'm in the section. So what, can you give me the is it section A and then a number, or?
Well, let's see.
I know it's a lot of letters and numbers.
I'm seeing two big A's there, Danny. There's two big A's. It's the second big A.
Second big A. Okay, I see. The risk of cannabis use disorder. Okay, correct.
Okay, so I'm just comparing the risks that are enumerated here with what was in the prior bill. And the first thing I notice is that in the prior bill, the first thing that was on the list that has been removed is the variability of the quality and concentration of cannabis products. I'm not quite sure why that would be removed as a risk.
That's okay. And beneath in the section where it says the risk of cannabis use disorder, in that section, there was one that talked about the variability of cannabis products.
The variability of the quality and concentration of cannabis products was formerly the first listed risk. I don't know if you have S-150 up there with you, but if you did, you would see what I'm talking about.
Yeah, I think later in the bill there is a discussion in regard to the toleration or the deviation of how it's labeled and how it can vary. I'm guessing that it was done because it was redundant, but again, as with earlier, what you said earlier, if we want to make it explicit and say it again, I've got no problem with that. It was my intention to present a more refined work product without changing the underlying substance, but if the body feels more comfortable including it again in that section, I have no problem with that. The variability of cannabis products, I got that.
Senator, I will note that in section 4453-2060, you appear to have strengthened the penalty for what I would call prescribing abuse, which obviously I don't have any issue with that, because did you know that if someone's abusing the prescribing privilege, they ought to face some kind of penalty? But I just will note for the body that I do think that's a strengthening provision there. And in 4453-2070, you've also strengthened the penalty for a pharmacist who would be prescribing, I guess, what I would call an abusive, overeager manner.
Right.
Now, I do want to get to 4453-2090. Senators, I recall the testimony, people for and against this, and I don't think I served on any subcommittees, but you'll remember we actually had testimony before full committee, I think, in one round of this. One thing that stuck out, or that I recall, is that in states that had accepted medical marijuana, when it was studied after the fact, it was found out that a lot of the people who obtained cards were young males, in their 20s, and that a lot of the underlying causes for which they were able to get those cards were PTSD. Does this ring a bell with you?
No, I do remember that, and that's one of the reasons why there is such detail in regard to a physician's authorization and the process that you have to go through. So you try to weed out, for lack of a better phrase, the bad actors or the people who are misrepresenting themselves. And what we've, in particular to PTSD, what we tried to do was, instead of just simply allowing a diagnosis of PTSD to be made and an authorization to be given, that there have to be acceptable evidence of traumatic events, which is defined as being along the lines of proof of military service in an active combat zone, victim of violent or sexual crime, or the person was a first responder. Again, the intent there is to get at, as best we can, making that which is subjective more objective, so you don't have people abusing it, so you don't have skewed numbers along the lines that you discussed. So that was the intent, and that was the attempt. And hopefully it works.
Well, I certainly appreciate the attempt to be objective, but, and this is just me speaking, to say anyone who has ever been a first responder, a volunteer firefighter, or whatever the list of first responders is, can automatically cite that as their evidence for PTSD and wanting a card seems pretty broad to me.
Well,
Did you know?
I think the thinking there is that the inherent nature of being a first responder means you're going to be presented with situations that are going to be characterized as traumatic by most people. So I think that was the inference there, is that if you're a first responder, by definition, you're going to be arriving at the scene of horrific incidences. So I think that was the reasoning behind that. Now again, just because you're in an active combat zone, or just because you were the victim of violent crime, or just because you're a first responder, doesn't mean that you automatically have PTSD. It is an attempt to bring some objectivity to something that is inherently more subjective in terms of diagnosis.
Senator, I understand that, but can you understand my concern that this is just an open door to the kind of card holders that were identified in other states under medical marijuana, young males who got the card on the evidence of PTSD, which is pretty subjective. And in my mind, when you say anyone who's been a first responder is now qualified, that to me is not so much of a limiting criteria as it is a criteria that just throws the door wide open to quite a lot of people. So I just point that out as...
That's fair. I mean, that's a fair observation. And again, I guess you're weighing here, on the one hand, giving people who desperately need access to it access, and at the same time trying to come up with a definition that weeds out those who aren't representing themselves honestly. And can I represent to you that this is going to weed out all those who are representing themselves dishonestly? I can't represent that to you. I can just give you the underlying reason for putting this in here.
I understand. And I do understand also, Senator, that we're involved in what is a balancing act here for people who desperately need pain relief and public safety on the other side of the equation, and trying not to create a situation where we have lots of people who are getting introduced to cannabis products because they're curious and now they have PTSD, and now we're creating a situation where unintentionally we're opening the door for people to start there and go on to something else. Can you understand that concern?
I understand the concern, and I can tell you that the way this legislation has been designed, starting from the fact that regulations have to be promulgated and approved on a continuous basis, the fact that we're going to have a sunset in 8 years and to reset and to take this all up again, it is implicit in that an admission that we're going to get some things wrong in here, or that we're going to get some things in terms of we think we're balancing it correctly, and maybe I turn out to be horribly wrong. It's set up in a way that forces me to then come back in a reauthorization and make the case again. So I've tried to build fail-safes into this, and in coming up with the 8 years in terms of the sunset, what I had to balance there was an ability for us to correct mistakes or unintended consequences against what the marketplace needs in terms of, if they're going to invest capital, the amount of time they need to get a return on capital. So that's why there's 8 years. So that's the balance I tried to strike there. But again, I take your point. I mean, we're trying to do balancing here. I'm trying to come up with a process whereby you don't have fraudulent actors. I can't represent to you that this is going to get it right. I can represent to you that there is built into this bill opportunities to correct it and get it right in the future.
And I appreciate that, Senator. I think you'll recall that the sunset clause was
your idea.
Pretty critical.
Yep.
Because we're all aware of trying our best with legislation and having unintended consequences.
I think, frankly, I mean, Senator Clymer, I think, had this point made at one point that regulations ought to maybe have automatic sunsets every 5 years, so that we're forced to evaluate them to see whether or not the assumptions we made in regard to public safety being promoted are visited anew. So I think it's probably a good idea for us to be forced on a regular basis to kind of revisit things. And I think, particularly in regard to something like this, when we're entering into new space, we have to have some humility and recognition that we're going to get some things wrong.
Well, I'll make one point here about the sunset clause, and then I'll try to keep moving here. I think in the original bill, did you know the sunset was 6 years? And now you've moved it to 8, and I just heard the explanation, which is trying to give people an opportunity to have return on capital. But again, if there's unintended consequences and they're screaming at us after 4 years, then in my shoes, 8 years becomes a long time to correct them.
But there's also, I didn't mean to interrupt you, but let me also say this. There's also, again, built into this bill, the ability for the Department of Public Health, or it's DHEC in here, but it's going to be Department of Public Health once the restructuring is implemented. And the Board of Pharmacy has the right continuously to submit regulations, much like DHEC and other agencies do now. So you're going to see corrective measures or things being undertaken as what we're authorizing here is actually implemented in the marketplace. And as things become apparent, you're going to see regulations proposed to kind of address those things. So I don't mean to suggest to you that we're just locked in for 8 years and this is what we're going to have to live with. There's going to be an opportunity for us on a continuing basis through regulation. This is a very heavily regulated space to go back in and refine those regulations to address things that we didn't consider properly.
Okay. All right, so moving on, I will note that you've strengthened the security requirements for people who are caregivers, have to give a complete set of fingerprints. So I think that's helpful. Let's talk for a minute about the pharmacy and the pharmacist's role, because there's a few things here that looks like we've moved from the pharmacist to a pharmacist or other therapeutic cannabis pharmacy staffer. In other words, I find a few places here where it looks like, or where I recall 2 years ago, we were trying to put the pharmacist in the place of, if someone comes into the pharmacy, Senator, and they've got a recommendation, I think we call it, from the doctor, and they don't know anything about the various products. The idea was that a pharmacist would be able to kind of talk to them and help them choose the best product, right? And maybe the amount of the products they should try to start with and so forth. So I think we had the pharmacist in a pretty prominent role, but I'm finding a few instances here where we've gone from pharmacist to pharmacist or other therapeutic cannabis pharmacy staffer. So what is the role of the pharmacist?
Let me. And this is an example of consolidating things in a clearer way. Section 44-53-2490 of the current bill. If you turn to that section, 44-53-2490.
Forty-four, 53, 2390.
2490. Sorry.
Okay, I'm there.
Okay, and yes, so let me kind of read it out loud and then we can talk about it. Each therapeutic cannabis pharmacy must employ a pharmacist in charge who is licensed by the state as a pharmacist and who completed a medical cannabis continuing education course approved by the South Carolina Board of Pharmacy as provided by Section 4453-2074A. A pharmacist must be reasonably available during business hours to advise and educate patients in person, and in connection with providing such advice and education, shall be subject to being sued by a patient for negligence in the event the pharmacist violates the applicable standard of care. A pharmacist must be physically on premises during dispensing hours. So what we tried to make clear here is that there ultimately is going to be a pharmacist who is charged with responsibility for everything that occurs in that therapeutic pharmacy, but there are going to be non-pharmacists that will actually maybe be working as assistants, but notwithstanding that, there's going to be vicarious liability back to that pharmacist in charge, who always has to be on the premises, who always has to be available for consultation, and can be sued for negligence in the event they are not. So I think that was an attempt to put it all in one section in a very clear way so that a pharmacist was very clear of what his or her responsibilities are.
All right, but I do think this is a fairly substantial change. Let's talk about the pharmacy.
Okay.
You go into a pharmacy, and let's just say there's 3 people in there, or there's 5 people in there. And someone's curious about the various products and the recommendation they've received from the physician, and they've got that pharmacist's attention. They may be talking to him for 30 minutes. I mean, I'm going to be talking to him for a while before I start putting something into my body that is what I, for lack of a better term, would call alternative drug or medicine, okay?
Sure.
It's not like, well, here's the FDA-approved pill, you take one every 8 hours or whatever. This is a little bit more of a right-to-try situation to hopefully figure out what works for you, right?
I think it's important to have that pharmacist guidance there for that reason.
Well, that's what I'm concerned about, is that under this section, on point number B, in the old bill it said each pharmacist who dispenses cannabis products to qualifying patients, and now it says each pharmacist and other therapeutic cannabis pharmacy staffer authorized by the Board of Pharmacy who all of a sudden, we've got people, I think, who are dealing with the patients and answering their questions if there's multiple patients in the store, and that person's not a pharmacist. That person is maybe I would assume, gotten some level of education or training.
In fairness, though, again, Section A says that the pharmacist must be reasonably available during business hours, must educate patients in person, must be physically on the premises, and can be sued by negligence in the event that the standard of care isn't issued. So, it's true. If you go to a Walgreens now, everybody you see behind that counter is not a pharmacist. You got people that are putting things in bags, and people that are ringing up sales, and people are doing collateral things that aren't the best use of a pharmacist's time. But a pharmacist is there for the purpose of consulting. And yeah, you may have to wait if there's somebody in front of you in line. But that's the nature of going to any establishment. If there's somebody in front of you, you're going to have to wait. I don't know what else we can do other than say there's got to be a pharmacist in charge. That pharmacist is in charge of whatever happens on that premises, and they can be sued for negligence in the event standard of care isn't realized. I'm not sure what else we can say there.
Well, did you know, Senator, I'm simply going to make the point that, again, we're talking about an alternative medicine where I come into the store with a recommendation, and I'm not even sure whether I'm looking for an edible or an oil that I'm going to rub on my skin or something I'm going to vape, right? And so it's not the same as whoever's standing behind the counter at Walgreens counting pills out that are specific to my prescription. In my mind, this is a pretty different situation altogether. Now, I realize that you said the pharmacist, the buck stops there. He's the one who's going to get sued if this goes sideways, right? And it's determined that whoever spoke to him didn't follow reasonable care. I think some terminology of that.
And implicit in that, as an attorney, I'll say this, that if you have an establishment where the ratio of the pharmacists there to non-pharmacists is so great, I would think that's laying the predicate for a negligence cause of action, because you could say you can't possibly be supervising or being involved in all these transactions with that volume of business. So that would go to negligence. Again, negligence is an elastic concept based on reasonable care given the circumstances. And so there's only so much you can do in written legislation. I mean, you've got to rely upon the common law and what negligence and reasonable care means in the common law in order for some of these duties to be fleshed out. You can't do it legislatively to the degree that I think we might be trying to.
All right, let's move on from that. Senator, this next question is going to involve a section of, well, a few sentences that were deleted from S-150
Okay.
that I'm a little puzzled about, but trying to find the section to get you there. It's like we're under 4453-2170, and it's about 3 pages in under big letter I. Okay. Nothing in this chapter requires a pharmacist to obtain information about a patient from the Medical Cannabis Authorization Monitoring Program. You see that?
Nothing in this chapter requires a pharmacist to obtain information about a patient from the Medical Cannabis Authorization Monitoring Program. As distinguished from, I think there's an obligation on the part of the physician when giving a written certification to authorize the use that they have to review that history. This is stating that the pharmacist does not have to access that same monitoring program, because that's not the level of diligence that they do at that dispensing level.
All right, so it's the physician
that does that,
who was required to look back into drug abuse potential.
Right. I think, yeah, and that was more, I'm trying to remember the reason for that, but I think that was considered to be more of a diligence level that a doctor has to do when authorizing, as opposed to a pharmacist diligence level when dispensing.
Okay. Let's move forward to section 4453-2210. This gets to kind of unlawful use. If you'll see large letter B, it is unlawful for a cardholder to possess cannabis in plant form or to smoke cannabis. All right. After large letter B, you've deleted one sentence that says, which used to be large letter C, which says in the old bill, a violation of this section for possession of more than an ounce of marijuana or 10 grams of hashish is punishable pursuant to section 4453-370. So you've deleted that sentence.
I think, yeah.
Go ahead.
And I remember that because this bill doesn't speak to hashish. This bill talks about authorizing use of cannabis products. And so that language that crept in there is in regard to, is beyond the subject matter of this bill. I mean, I think that's the reason that was deleted. Hashish is illegal under other sections of the code.
Okay, let's move forward to 4453-2230, and this has to do with the possession of cannabis products in your vehicle.
Okay.
Okay, it looks like in S-150 that if you had products, they had to be in your trunk, glove compartment, closed console, luggage compartment, that you just could not have it in any kind of open container. And here, it really just speaks about, well, you cannot vape while you're in the car. It has done away with the open container kind of prohibition. I don't know if you remember that from
Yeah,
S-150, but that's what's
I
in there.
think, and again, as I recall, the concern was you didn't want somebody who was driving down the road vaping. And so in cleaning this up, I focused on that. I focused on saying you can't vape. If you want to add in there, you can't have it sort of like an open container analogy there. I've got no quarrel with that. I was trying to get to the heart of what was trying to be prevented, which is vaping while driving. But if we want to go ahead and extend that by analogy to an open container, we could do that.
Okay, I'll just note in passing that you did add a section here having to do with Second Amendment.
Right.
453-2290.
Correct. Nothing in this act shall be interpreted to require or allow a person or entity to infringe on another person's right to own or possess a firearm, ammunition, or receive any related firearm certification.
Okay, going forward to section 4453-2410.
Okay.
Several pages down, capital letter F.
Starts with prior to operating.
Correct.
Okay.
You've added, that second sentence there was not in 150. It has to do with the fact that the license was not renewed on time. I mean, you've added what I would call a grace period. I don't know if this is normal for other types of business licenses. I'm not sure why that's been put in there.
Yeah, that was, and it is similar to after license expiration dates, there usually is a grace period, and so we put in renewed within 90 days after expiration, so there is a grace period in there. Again, I'm not wed to that language if we wanted to make it tighter or more permissive, but it falls within the norm when you have to renew licenses.
Okay, I note in 4453-2420, that again, I think you've strengthened the security requirements there for background checks.
That was, and you're right, I have, because one of the things that I recall coming up during the debate a couple years ago were making sure that employees of these establishments were good characters, and so I did make a conscious effort to provide further assurances in that regard.
Let's go to section 44532520. I don't know if this is going to open a can of worms, Senator, but this appears to be maybe where you were trying to have some fees specified, because I think the hang up in the House before was over the whole bill being a fundraising bill. And so it looks to me like this is inserted here to try to garner some revenue without maybe crossing the line. Am I interpreting that correctly?
It is. I mean, it directs the department to establish fees to defray the costs of administering the program. Let me make this observation because I think it's a timely place for me to make it. I had a conversation with the DOR, Department of Revenue, and it's their opinion that since medical cannabis is not a controlled substance, that the sales tax exemption that applies to controlled substances would not apply to the sale of medical cannabis. In other words, it would be subject to that sales tax. Last year, I tried to be explicit in that regard and say that which I thought was obvious. I said the medical cannabis sales are subject to the state sales tax, which I think that they are for the reasons I've just said. But I ended up being hoisted on my own petard because I then gave them a reason to say, aha, you're saying here you're subjecting this to a sales tax. That's a tax revenue, that's a revenue raising device. And so I kind of sowed the seeds for my own destruction there. So, but anyway, that was deleted. And I think we still had in the prior bill authorization for the department, and here the pharmacy board too, to establish fees. It had them in that previous bill too. The other difference is that the revenues raised through those fees can only go to defray the cost of administering the program. If you recall, 150, and artfully on my part, had monies going to SLED and to other areas too. And I think that also kind of got me afoul of the revenue-raising prohibition in the Constitution. So I think, based on the experiences of other states, with sales tax being applicable and with fees being assigned, I do think that the fiscal impact, which is $5 million, I think is what the DHEC had said this might cost them. I do think that's going to be defrayed. But again, that's an instance where we're not going to know until it's put into practice and we know the number of people that are actually participating in the program and consuming it and know what the revenues are. And so there's flexibility among these departments to raise their fees or conversely lower those fees if the fees are more than necessary to defray their costs. So the revenue piece of this is a little fluid for those reasons.
All right, let's go forward to section 4453, 2560.
2560?
Correct.
Okay. Members of the General Assembly. Yes, sir.
All right. The way I've read the bill, correct me if I'm wrong, but I believe that you removed this stipulation from several different sections where it was in the old bill, and you just put it here once, kind of to cover the whole thing.
Right.
Is that correct?
Yeah, as I recall.
Because it was in several different places before, then it's no longer there. But this, I think, is kind of put there to cover all the instances where you've removed it.
It was meant to be comprehensive in regard to the prohibition as opposed to having it scattered throughout the bill.
And I think this is fairly well the same prohibition that you had before, but did you know, Senator, the last sentence of that, I'm certainly going to put up an amendment to get rid of. I don't think that anyone should be able to recuse themselves from this vote and then go into the business.
That's fine.
It's just too easy for someone to say, well, I want to be in the business and this bill is going to pass. It doesn't need my vote. I'm not saying that anyone would do that. I just think it's a loophole that's got to be closed.
Fair enough.
Senator, that pretty much gets me to the end of what I think are the relevant differences between this and the prior bill. Probably a few things there that concern me, but did you know I do find that it is, by and large, very similar to the bill that was passed 2 years ago.
Thank you, Senator. Let me pick up on the rest of I've got like 10 more minutes to go, and then I'm done with my presentation.
Do you
I'm
refuse?
happy to yield, Senator from
Okay,
Georgetown.
Senator from Georgetown, what purpose do you rise, sir?
Would you prefer I wait?
I'm happy to yield.
Okay, Senator, yield for a question.
Senator Yields. Senator Yields.
Senator, just one point in y'all's exchange, you were talking about PTSD, and I felt a need to jump up. I'm a little behind now, but did you know I served in a combat zone recently?
Good.
Did you know that when you come out of a combat zone, you are extensively evaluated for PTSD?
I did not know that.
You are. If you didn't know, you were extensively evaluated for PTSD. And did you know that there is extreme stigma and consequences of being diagnosed with PTSD while being in the military?
Did not know that.
Yeah, there are, Senator. And the point I'd like to make to you, did you know that nobody seeks a diagnosis of PTSD in the military? It has extreme consequences, did you know? And nobody that I know that has come out of a combat zone is seeking a PTSD diagnosis so that they can get high. Did you know that?
Sir,
Thank you.
thank you. I'll yield to my friend from Greenville.
Senator from Greenville, Senator Corbin, what purpose do you rise, sir?
Senator Yield for a question?
Sure, Senator Yield.
Senator Yields for question.
Thank you, Senator. I just had a question about, it's actually, if you want to look, it's on page 2. I'm old-fashioned, kind of like you, I print everything out. So I threw away the first page because it just had one line. So I guess technically it'll be on page 4. But what I'm looking at is on page 3, and it's under sort of the definitions. Mm-hmm. And under section 4453, 2010, section 1, and when it gets to I, it says that cannabis products, and this is talking about the amount of tetrahydrocannabinol. Am I pronouncing that right? Can I say THC? THC. That's the component that makes you high, right?
Yes, it is.
Okay.
So I've heard.
Right. Cannabis products for topical administration, like patches and creams, can have no more than 4,000 milligrams of THC. Okay, below that it says cannabis products for oral administration, which, you would put that into your body, including but not limited to oils, tinctures, capsules, edible forms, are limited to 1,600 milligrams. So that is, like a third of the other. Now, when you get down to cannabis products for oils for vaping, it goes to 8,200 milligrams of THC. Why is that? I mean, the vaping to me is very similar to burning the leaf. So why are we allowing so much more THC in the vaping than the oral ingested in the...
It's a great question. This particular issue was taken up in a subcommittee. I don't remember which one. But it is based on what the Ohio Board of Pharmacy did. And I was persuaded that they had a methodology in regard to the different absorption rates for topical, oral, and vaporization. And I followed verbatim what the Ohio Board of Pharmacy considered to be, quote, reasonably safe THC content for non-plant forms of medical marijuana. So it's a way of getting at different absorption rates during the different consumption modes. And again, I'm going to defer to the expertise that we had in subcommittee from the Board of Pharmacy in Ohio.
It just seems to me like if you suck something into your lungs, I think the lungs absorb it rather quickly, and that's where you catch the flu and pneumonia by being encapsulated down into the lung tissue area. But while we're allowing 5 times the amount of THC to be ingested that way as opposed to others,
It's twice the amount of topical, and as you say, 5.5 times the amount of oral. Again, in terms of absorption rates and how it interacts with the body, that gets beyond my expertise. I want to go ahead and continue.
Excuse me, Senator from Charleston, Senator Sin, has, what purpose do you rise?
To see if the senator would yield for one question.
What's it? Senator yields for question.
At one point, we discussed that you were going to place in the bill that there could be no more than 3 of these dispensaries per county. Is that in the bill?
There is an ability for a county to completely ban it through their regulations. There is no hard cap in the code, but there is a provision that says if you're a municipality or a county and local land use regulation, you can completely ban the establishments.
But why can't we go ahead and put it in this bill? Just like we did in the Costco and whenever they were trying to come in and put a bunch of Costcos and take over the liquor stores in the area.
It wasn't in the bill that we passed last time, but I'm happy to have you offer up an amendment. We can debate it.
Thank you. You remember that you were supposed to go try and get that in over in the House, and that didn't happen. We talked about it. So if you would, please.
Yeah. The reason it's not in there now, Senator from Charleston, is my representation to this body was it was going to be materially similar to what the Senate had passed. But if there are other amendments that want to be offered, if they're meritorious, I'll support them.
Thank you.
There were certain concerns, Senator from Charleston, while you're up. You made some good points last time about advertising and the seediness of some of these cities that have it. And so there is a substantial language in here regarding requirements that a medical cannabis establishment's logo, advertising, and signage be tasteful, respectful, medically focused, not appeal to minors, not contain cartoon-like figures or attempts at humor, doesn't allow the marijuana leaf or slang. I tried to include language in there to address the overall aesthetic concern that you had voiced, and I draw your attention to that section to see if it's satisfactory. Because if it's not, I'm happy to entertain amendments there too. But it's in section 44-53-2370. And it relates to how a business goes about advertising its services.
Because did you know, in my area, just in the last 2 weeks, every day when I go home, and this is in Charleston, I also have the same thing every day when I go home in Columbia to my sister's house. One of them has a big pot leaf, and it calls itself a pharmacia, or pharmacy spelled with an F. But the one in Charleston now has the marijuana leaf, and it calls itself a dispensary.
Okay, thank you. The senator from Lexington, Senator Shealy, raised some points last time in regard to marketing to children or making these products attractive to children. There are substantial provisions in here in regard to their restrictions on the forms, appearance, and flavor of edible cannabis products and syrups to reduce their appeal to minors, including prohibiting edible cannabis products in the shapes of cartoons, toys, animals, or people. And I also was going to include in there, Senator Cash, cherry-flavored cough drops that you said you burned through one time because they tasted so good. But that was sort of the intent behind this, too, is to get around the flavors that would attract children. Not that you're a child. Again, there's provisions in here regarding seed-to-sale tracking. We talked about that in terms of 24/7 tracking, where you can have the product under surveillance at all points of production. Law enforcement has access to every one of these establishments with or without notice. It's, again, has all those provisions we had in the prior bill as well. With that, there are other aspects to the bill too, but again, most of you are familiar with them because we had a 3-week debate. So at this point in time, I'm happy to yield the podium, Mr. President, and so others can be heard on this particular bill, unless somebody else has questions of me.
Before we do, Senator from Clarendon, what purpose do you rise?
I was going to ask be heard if the senator was finished.
Yes. Thank you, Mr. President.
We have to go to the amendments now, so this was an explanation on the bill that's allowed under our rules. Thank you, Senator from Beaufort. Reading clerk will publish the amendment.
Member number 1 by Senator Corbin, amends the bill, Section 4. Strike Section 4453, 2260, subsection E, and insert subsection E, except as otherwise provided by this section.
Senator
Provisions of
from
this order.
Greenville, Senator Corbin, what purpose do you rise, sir?
To explain the amendment?
You're recognized to explain your amendment.
The chamber is pretty devoid of senators. I hope they're listening outside. First off, I'd like to thank the senator from Beaufort. He has gone above and beyond on this bill to try to meet the needs and concerns of everybody that puts forth a concern about making it a good bill, a tight bill, and yet doing something that he feels passionate about. But in saying that, I will say that I believe he missed one little technical thing that I would like to correct here. There's a part in the bill in section 4453 2260E where it talks about landlords and their rights and tenants. As you know, we've always, I believe most in this body believe in property rights. And basically what this amendment does is it says that if you're a landlord, you have the right to put into the lease that you cannot vape this product in the house. Now, it doesn't say that you can't use the product. It doesn't say that you can't use the oils and the patches or eat the gummies or whatnot, but that you just can't vape it inside the house. Because I spoke with some folks I know back home this morning who actually do vape for various reasons, because I had a concern about that. And I asked them, I said, is there an odor when you vape this stuff? Is it leave an odor? And every one of them said, yes, it does. And it can be pretty prominent. So basically the amendment says that, that you just can't vape inside the house. If there are no questions.
Senator from Beaufort, what purpose do you rise, sir?
If the senator would yield.
Senator yield for questions. Senator yields for questions.
And thank you, Senator, for offering this amendment. It's as we discussed before, it's a question of balancing, on the one hand, a landlord's right to control what happens on property they own with the right of a patient to access medicine that a physician has said will help address a medical condition. I tried to strike that balance in here by saying that a landlord may not prohibit a tenant who is a cardholder from vaporizing cannabis products that cannot be smelled outside of the cardholder's rented dwelling unit. So I guess I was speaking there to a landlord's desire to make sure that somebody's use of that premises didn't interfere with the quiet enjoyment of a neighbor. You're speaking to, I guess, whether or not the odor or the smell gets into the premises and therefore diminishes the landowner's property.
And Senator, could cause damage. You know, a lot of landlords are writing to at least no smoking in the home. Or some have no pet, some rentals are pet friendly, some aren't, but that's always kind of been a landlord. Anything that could affect the value of the home or cause that landlord to have to spend money is always sort of been able to written into the lease.
I think that's a fair point. I think I would make a distinction that there's a distinction between consuming medicine that a physician says you need to address a medical condition and smoking and having a pet. But again, it's where you decide to balance those two rights.
And Senator, that's why I was trying to balance that as well. It's not that they can't vape it. It's just they can't vape it inside the house. They can step out on the porch. They can vape it, in the yard, but just not in a position where it could, cause the landlord an expensive repair or having to repaint or rip out carpet or something like that over, extensive use.
I'm content for the body to work its will on this and to have a vote on this amendment.
Thank you. No other questions? I'll move for passage.
Pending question is the adoption of the amendment. Roll call has been requested. Do 5 members second that call? 1, 2, 3, 4, 5. More than 5. The clerk has rung the bell. The reading clerk will please call the roll of the Senate. Pending question is adoption of the amendment.
Mr. Adams. Not voting, Mr. Alexander. Aye. Mr. Allen. Not voting, Mr. Bennett. Not voting, Mr. Campson. Not voting, Mr. Cash. Aye. Mr. Clymer. Not voting, Mr. Corbin. Aye. Mr. Cromer. Not voting, Mr. Davis. No. Mrs. Devine. No. Mr. Fanning. No. Mr. Gambrell. Aye. Mr. Garrett. Aye. Mr. Goldfinch. Not voting, Mr. Grooms. Not voting, Mrs. Gustafson. Mrs. Gustafson votes no. Mr. Harpootlian. Not voting, Mr. Hembry. Aye. Mr. Hutto. No. Mr. Jackson. No. Mr. Kevin Johnson. Aye. Mr. Michael Johnson. Not voting, Mr. Kimbrell. Aye. Mr. Loftus. Aye. Mr. Malloy. Not voting, Mr. Martin. Aye. Mr. Massey. Aye. Mrs. Matthews has leave. Mr. McElveen. Not voting, Ms. McLeod. Not voting, Mr. Peeler. Aye. Mr. Rankin. Not voting, Mr. Rickenbaugh. Aye. Mr. Rice. Aye. Mr. Sabb has leave. Mrs. Sin. Aye. Mr. Setzler. Aye. Mrs. Shealy. Aye. Mr. Stevens. No. Mr. Talley. Aye. Mr. Tedder. No. Mr. Turner. Aye. Mr. Verdon. Aye. Mr. Williams. Not voting, Mr. Young. Mr. Young votes aye.
Have all senators voted? Have all senators voted? Senator from Orangeburg, what purpose do you ask?
Stand for leave for the senator from Richland, Senator Harpootlian.
Without objection. Senator Cromer votes aye. Senator Campson votes aye. Senator Bennett votes aye. Senator Shealy votes no. Senator Goldfinch votes aye. Senator Allen votes no. Senator McElveen votes aye. Senator McLeod votes no. Senator Adams votes aye. Senator Michael Johnson votes aye. Senator Malloy votes no. Senator Rankin votes aye. Senator Clymer votes aye. Senator Williams votes aye. Further members wishing to cast your vote? Have all members voted? All members voted. The polls will close and the clerk will tabulate. By a vote of 30 to 12, the amendment is adopted. There's no further amendments. Senator from Clarendon, what purpose do you ask, sir?
Mr. President, I'd like to be heard briefly.
You're recognized on the bill.
Just one amendment.
Senator from Clarendon.
Thank you, Mr. President. Members, I think week before last, there was a vote, a motion was made to put this bill on special order, and I voted against it. And then I had a chance to think about it over the weekend, And although I'm known for being against the bill, I really felt that, we ought to have the chance to debate the bill. There's a couple of bills that I'm interested in now that we don't have the chance to debate, and I regret that. So I know the feeling when you want to talk about something and you're not allowed to. And so I was told that if I didn't vote when the motion came back up again, that would help the bill sponsor get the bill on special order. So that's what I did. I want to just say, and I'm going to be brief because I've had the same position since this bill was first proposed. At one point, I was on the subcommittee and put a lot of time and a lot of work into it. Then somehow I wasn't on the subcommittee anymore. So I think my position is known, so I'm not going to be very long. But one of the things that first formed my opinion about medical marijuana, in particular, were two pediatricians, one from Florence County and one from Clarendon County, who I have the utmost respect for. They're good doctors, and they just convinced me that medical marijuana would be bad for young people. They were telling me, and they were able to demonstrate to me, how the number of young people that came to their practice, how the number that were dependent on marijuana was increasing rapidly. And so I know that we talk a lot of times about older people and other medical conditions, but the fact of the matter is that if this bill passes, just like people abuse opioids, and there are a lot of folks who have access to opioids who don't have prescriptions, a lot of folks who won't be authorized to have medical marijuana, they're going to get it. It's going to be mostly young people. I think a lot of times about, at least in my school district and in my area, how so many young people, and when I say young, I mean young, I'm talking about below high school, so far their lives are messed up because of marijuana. And it's amazing. I remember one time somebody told me that one of our basketball teams, they had to cancel the game because all the players, and this was the female team, were high on marijuana. But anyway, I hear the argument that was made that some 37 states have passed medical marijuana. And I would say again, that doesn't sway with me, because if that were important, then we would have hate crime legislation, because 48 states and the House of Representatives have passed hate crime. So that doesn't sway with me. As I said, I've been involved in this bill for a long time, spent a lot of time on it. I remember one subcommittee meeting lasted about 5 hours, and the testimony was intense on both sides of the issue. One thing I found out when I served in that subcommittee, because there were a lot of reports and statistics and data that were presented to us, and I'll just tell you right now, regardless of what your stance is on this bill, you can find enough documentation to support your stance, whether you're for it or whether you're against it. So my thing is that if medical marijuana, if there really is medicinal value to marijuana, and I know that in some cases, maybe that's the case, but if there really is overall medicinal value in marijuana, why doesn't the FDA reschedule it and have it so that doctors can prescribe marijuana? I would tell you, you all know that I'm dealing with excruciating back pain as we speak. One of the reasons why I'm not going to stand here too long, because I probably can't. It's a struggle to walk around. And I've been dealing with this for the last 3 or 4 years. I get injections. I've been prescribed different painkillers. But I have a great family, my doctor, my personal doctor, outstanding. I have a lot of faith in him. And my pain management doctor over in Florence, great doctor. And they know, how I suffer with my back. And not one time have they even hinted that I should try medical marijuana. And I really believe, knowing them as I do, that if they thought that it would help me, they would have recommended that. Not that I would try it, but that's why, another reason why I don't think that it has a lot of medicinal value. The law enforcement that I talk to, they tend to be against the bill. Now, I hadn't talked to them lately, and as I said many times, in particular to the senator from Beaufort, when I first was appointed to this subcommittee, this was a terrible bill. It really was a terrible bill. And a lot of the folks that came to me wanting me to support the bill, and I used to call them potheads. I don't want to say that anymore. But I could tell from the moment they walked in my office that they used a lot of marijuana, and it wasn't because of pain. They just liked getting high, and they saw this bill as a way to have access to marijuana that was different than going out and dealing with a dealer. So I talked to a lot of law enforcement, even when I'm out of town especially, and especially if I'm in a town or a city where marijuana is legal, even for recreational use. I was in Charlotte over the Christmas holidays. I went to see a couple of NBA games, and when I go to NBA games, I like to go in early and watch the players warm up and all that kind of stuff, and yeah, I just like that. And going to the arena, my hotel was right across the street, and you know, all you could smell is marijuana, which I think is one of the most awful smells that exists. But anyhow, I got to talking again like I normally do to a police officer. And I asked him about, I left my information over there, so I have to try to remember, about my phone, about marijuana and what they thought about it, and he didn't have anything good to say about it. And I told him where we were with medical marijuana and how we were debating that in South Carolina. And he said, anybody that you know that is considering marijuana, especially legislators, I'm trying to find the title of the book. I just want to get that out. He said, I recommend to you that they read this book. And I'm not going to waste too much time, but it was something about, I don't think I wrote it down, but it was something about the truth about marijuana. And it was talking about marijuana, again, as it relates to young people. And it talked about how it contributes to mental health and violence and those types of things. And it's a pretty good read. I didn't read the whole book, but I read bits and pieces of it, and I know there are some parts that are highly debatable, but it makes a great case on how marijuana affects young people. And the premise of the book was, let's tell these young people the truth. And there were several reviews in the book. One of the reviews said, marijuana legalization advocates have misled Americans about the drug's safety. For decades, advocacy groups have pushed dangerous myths about cannabis. It can treat many different diseases like cancer and glaucoma and all kind of other things it said that it could treat. But the book was saying that that's just not necessarily the case. It points out that there is a higher use of marijuana now in America. And over the last 20 years, marijuana has become far more potent. It says that a lot of people who propose medical marijuana kind of refer to it as though it's a magic bullet, that it can cure anxiety, glaucoma, arthritis, autism, seizures, and so on and so on. And so I tend to agree with that part of the book because when I consider bills up here a lot, I try to look at how they affect people I know. And I know a lot of people that are heavy users of marijuana. And they suffer with pain. Some of them have cancer, have died of cancer, and these other ailments. And so my mind says, now, if marijuana provides relief for these types of illnesses, and I'm telling you, I know people who suffer with these illnesses, and they haven't found any relief from all that marijuana that they smoke. And so I'll end with this. The Behavioral Health Services Association of South Carolina, formerly known as the Alcohol and Drug Abuse, they have an annual conference every year.
Senator from Beaufort, what purpose do you answer?
Question, but I'll let him finish, sir.
I'm coming to a close.
Okay.
So they have an annual conference every year, and I'm always asked to serve on their legislative panel. And this past year, it was 2 weekends ago, we had the conference, and there were about close to 300 people, attendees, and these attendees are mainly board members for the County Behavioral Health Services Association for each county, and also the administrators and some of the employees. And for the last, I think every year I've gone, the major bone of contention, and the major topic that we discuss is medical marijuana. And so I'm sitting there in a room with 300 people who deal with this either for a living or as a volunteer board member, and these people really have a passion for people who are dealing with substance abuse. And I don't think out of the years I've been going, and the hundreds and probably up into the thousands of people that I have spoken to, I don't think there's one person in that particular group that are proponents of medical marijuana. And that carries a lot of weight with me. And I'm telling you, if our session is an hour and a half, an hour and 10 minutes is devoted to they want to talk about medical marijuana. And so the other thing I want to say, this is my final point, I like the fact that there's there's a sunset. But I think I agree with somebody got up a while ago about the sunset. I think 8 years is too long, because if for some reason medical marijuana is not the answer, a lot of damage can be done in 8 years. And so I'll end with that, Senator, and I'll be happy to yield to.
Thank you, Senator. Senator from Beaufort, what purpose do you ask, sir?
If the senator would yield for some questions.
Senator, yield for questions. Senator yields.
Senator, did you know that that sometimes the advocates of this bill can hurt the effort because they do overstate things? They do suggest that marijuana is a silver bullet. They do suggest that it can be a panacea, that's a cure of all ills. And to your point, I think it's like anything else in medicine. Sometimes it helps and sometimes it doesn't, and it's going to be a doctor in consultation with a patient. But I think you're right to point out that these overblown claims don't necessarily help the legislation. That's a fair point. I think you also make a good point about that book, and I've read that book as well, and it makes the point that young adolescents in particular, if they have mental disorders or anxiety, that cannabis can actually exacerbate that and actually, make the problem much worse. And that really informed my decision in this bill to require that in instances where a physician who is seeking to authorize the use of cannabis notes a history of substance abuse or notes a history of mental disorders, that a specialist has to be involved to consult for that very reason, for that danger. So you make a fair point in that regard as well. And then the last point, did you know, that I would make in regard to the 8-year sunset, it was a balance between, what can we do to sunset something to set the course straight again against somebody having to have a certain amount of time to recover the capital investment. But did you know that I would suggest to you that the ability of DHEC and the Board of Pharmacy to promulgate regulations and bring them before us over time somewhat mitigates that problem. But I think you have always been a very thoughtful critic of this bill, and you have been in good faith an opponent, but you've always given your reasons, and I appreciate you for that, sir.
Thank you, Senator. And you're correct. I talked about the two pediatricians that really formed my opinion. But what strengthened the opinion that I had against this bill were those type people. And the example I give was a fellow that came in my office. He said he was a veteran. He came in his wheelchair, rolled himself in, and he was just really speaking as to how much marijuana helps his conditions. And I sat there and I listened very intently, and I really felt sorry for the guy. I really did. And he hadn't left my office probably not even 2 minutes until I got a phone call from somebody that knew he was coming. And they explained to me that the guy was a fraud. There's not a thing wrong with him except he just loved marijuana. And he borrowed the wheelchair to roll himself into my office. And the other thing I want to say as I take my seat, because I just want to emphasize this. I said it earlier, but I think you said 2000 and maybe 11 or whatever. I just want to commend the senator from Beaufort, because in my opinion, this was a terrible, terrible bill that I was just hoping it would not pass. But you have listened to everybody that wanted to have some input on the bill. And the bill is a much better bill. Now, I'm not going to vote for it, but it's a much better bill to the point that if it does pass, I can live with it, whereas when we first started, I couldn't even live with it if it passed. So I want to thank you for that. You've been very attentive to some things that concern us a great deal. And I do understand, I'll say this because I know that the senator from Orangeburg, Senator Hutto, and I, we mainly agree on just about everything, but I know in a subcommittee meeting one day, and he pointed out how marijuana helped his father. And that just kind of told me, maybe it does help some people, but I think overall, I tend to agree with the studies that say that it does not have any value, although there are some exceptions, I'm sure.
Senator from Beaufort, what purpose do you rise, sir?
Senator would yield for two more questions.
Senator
friendly
yield for two questions. Senator yields.
Senator, did you know that when I was talking earlier about my friend Margaret Richardson and how, she handles her condition through the use of cannabis, that I stated that she would take a puff on a joint. She corrected me in saying that she vapes, she uses oil, so I wanted to make that clear. The other thing I think I said, exercising maybe some poetic license, I said it's not fair to have her have to go out there and buy from a dealer. She wanted to make it clear that she has to go to a trusted friend who gets it legally in another state. So I wanted to clarify those 2 points because I didn't want to misrepresent how she consumed cannabis. So thank you, Senator.
And I will say that at some point we debated. I was on that subcommittee, and it was really a pitiful sight to have parents bring their young kids to the subcommittee meeting, and they would have, from what we were told, and I believe it, hundreds and hundreds of seizures a day. They came to the subcommittee meetings wearing protective helmets so that when they would have seizures, they wouldn't damage their head. And so I was convinced that for whatever reason, there was something about the oil that when these young people had 100 seizures a day, they might only have 2 or 3. And I did support that, and I'm glad I supported that because, like I said, what I'm about here is how this whole thing affects our young people, and it's having a very, very detrimental impact on young people, at least where I live anyway.
Senator from Richland, Senator Jackson, what purpose do you rise, sir?
Thank you, Mr. President. Will Senator yield?
Senator yield for questions. Senator yields for questions.
Senator, did you know that you are one of my closest friends in this place? And I think I'm as close to you and your family as I am anyone. I love all you guys, and you all are fantastic. Did you also know that at one point I shared your view as relates to that? Did you also know that it was Margaret Richardson's testimony that really changed my opinion? You may or may not be aware that I served with Margaret's husband, Scott, and knew him very well, had a great relationship with him and knew Margaret. But I took your position, and it was difficult because not only am I a senator, I am a pastor of a church that some of your family members often visit.
Me too.
Yeah, you as well. And so, but when I heard, did you know that when I heard Margaret Richardson's testimony, it changed me as much as anything I've ever heard in my entire life, because I sincerely believe that she lived continuously with excruciating pain. Did you know that I went home that night and I said to my wife, you have to hear this testimony, pulled that testimony, shared it with other minister friends of mine and say, you have to hear this testimony. Because one of the things that those in here have often heard me say is that we make faceless decisions. We make decisions about policies and we can't connect a face to it. But when you did you know that when we put a face to one of those decisions, and that night, having heard her testimony, I could not sleep. The next morning, are you aware of the fact that I met with the senator from Beaufort, and we sat down and we talked to Margaret Richardson, talked to Scott, and left there feeling that this is a face to a problem or an issue that we have to connect the dots. Since then, I've met other people with similar situations, but I just want you to know that I appreciate your position. I shared your position at one time, but one courageous, suffering lady that a lot of us know changed my opinion. And I am glad that at least for this issue, I was able to put a face with the issue, and that changed my opinion. And that's why I am supporting this legislation.
Well, thank you, Senator. And let me just say this. I share the same feelings that you have, that you expressed for my family and myself. And I felt kind of funny one day because I saw a DJ. I was out the street, and he said, "Here's my favorite senator." And I said, "Oh, man, I can't believe he said that." But all jokes aside, and Senator, you are one of the most distinguished pastors and respected pastors in our state and region. So I knew that it was a good reason why you have the position you have. And I haven't met the lady, but I believe what you and the senator from Beaufort said about her. And I think that, I don't know, like I said, for some reason, most of the folks who came to me that I had face-to-face meetings with, they weren't like her. They had ulterior motives for wanting this bill to pass. And so I appreciate that. And for people like was it Margaret? Yeah, people like her, because I feel like this bill is going to pass. And if it does, like I said, I can live with this a better bill. But for people like her, if and when this bill passed, I'll be happy for her. But my comments are not to try to change anybody's opinion, but I just feel like I want it to be known again. And every time this bill comes up, I want to say how I feel about it. And I don't expect, Senator Davis, and I'm going to come back up to the podium because I don't want to beat a dead horse and I don't want to be repetitive. But since it came back up again, I wanted to just say again how I felt about it and why I feel the way I feel about it. But like I said, it's a better bill than what we began with.
Senator from Richland, Senator McLeod, what purpose do you ask?
Will the senator yield for just a question or two?
I will.
Senator, yields for questions.
Thank you, Senator. I know we've had conversations in the past about this particular issue.
You and the senator from Colleton even offered me some brownies that I turned down.
We did.
As much as I like brownies, I had to turn those down.
We were laughing about that earlier today, but you didn't take the bait, unfortunately. I want to go back to, and I really thought about not speaking on this issue again because I said so much when we debated this bill last time. Did you know that I am a co-sponsor of the bill again, and I am not only supportive, but really moved by the efforts of the senator from Beaufort and his persistence. I appreciate the fact that he has stayed the course. Did you know? But I wanted to just remind you, I listened intently to your remarks, did you know? And I can respect your opinion on the issue, and I hope that you can try to understand and respect mine as well.
Of course.
One of the things that I wanted to share is, did you know that my sister is a 2-time stage 4 breast cancer survivor?
I think I was somewhat aware of that.
And did you know that although your doctors don't feel that medical marijuana would be helpful to your back, that's unfortunate. There is research and several oncologists have determined that it is tremendously helpful to cancer patients. Did you know?
Well, I have seen that, but like I said earlier, I have seen research that says just the opposite. But you're talking about a personal experience that you are familiar with, up close and personal, and so I believe what you're saying as far as it relates to your sister.
Right, and did you know, I believe that you are like I am. I mean, we don't have to have cancer, or we don't have to have the condition that others may suffer with, but to understand that there are certain medicines that are extremely helpful to those of us who suffer with chronic pain. And did you know, I'm sure you do know, that I was diagnosed with sickle cell. And sickle cell is a part of this bill because research also shows that for those of us who have pain that is so intense that it cannot be managed at home, medical marijuana has been shown to be extremely helpful in that regard. And did you know that we have an opioid crisis in this state and in this country. Did you know that? Okay. And
I'm aware of that, Senator, and that's unfortunate. But I think that a part of the reason why we have an opioid crisis is because of people who are gaining access and abusing opioids that they get from family members or others who have been prescribed the drug, and they're actually using and abusing it. That's not the total reason. I know that people who depend on opioids sometimes unfortunately get dependent upon it, but I think there is a problem. But I think a lot of the problem, I won't say a lot of it, some of the problem is for people taking other people's opioids because they have their own reason why they want to do that. And so there is a problem. So we agree on that.
right. And do you remember that when I spoke from the well last year, I believe, on this particular issue, this bill, I brought a big bottle. I don't have it with me today, but it was still half full of opioids that I was prescribed, that I was afraid to take. Do you remember that?
I remember.
Okay. And the reason that I was afraid to take those opioids was not because I didn't have pain that required it, but I had to kind of teeter on that line because I was afraid to get too dependent on those drugs. But did you know that the doctors were more than willing to prescribe opioids for my pain, which was sickle cell pain, and that's not pain that any of us who struggle with sickle cell are able to manage at home. And did you know that marijuana is a natural remedy that has the ability to help alleviate a lot of that pain and keep us out of the keep us out of the ERs? Did you know that?
I'm aware of that.
Okay. And I would hope that even though I understand your concerns about the bill, I would hope that for those of us that it would actually help or could actually help, that you would consider voting for a remedy that is not an opioid, because those are prevalent and they are abused. And I'm sure, if this bill passes, there will be some who will, abuse medical marijuana as well. But for those of us who are challenged and suffer with chronic health conditions, I am a firm believer that medical marijuana would be helpful to your back, but that's another story for another day. I won't go into that. But for my sister and for those who suffer like I do with sickle cell painful crises, I would just ask that you would give us some consideration and not vote against the bill. Thank you.
Thank you, Senator. Let me say this as I go to my seat. The senator from Richland and the other senator from Richland, because of how we think, this is probably going to be one of the very, very, very few times we disagree. But I would say this, you all know what I do for a living, what I did pretty much all my life. I'm good with numbers, and I feel like the numbers are there. And I'm pretty sure I won't be voting for it, Senator, but I think the bill would pass. And if the bill passes, I'm happy for your sister, I'm happy for Ms. Margaret Fisher and people like that. But I'm telling you, there's a lot of people out there who don't have those issues that are going to try to use this bill for recreational marijuana use. It's going to happen. But, that's just, we deal with that when we get to it. Thank you very much.
Thank you.